My name is Angelo Stio. I am a partner with Troutman Pepper. I practice out of the Princeton and New York office. I'm one of the panelists here on the Hackers Personal Data Liability and Consumer Protection panel. Two of my other colleagues are here. I'll have them introduce themselves. Kevin, who was originally supposed to be in the panel, has come down with an illness, so we will try to fill his shoes on what he was going to discuss, but I'll turn it over just to Tom to introduce himself, and then Michael, and then we'll get into the program.
Hi, I'm Thomas Roback. I'm the chair of the Complex Litigation Group at Axon Philanthrop and Parkwriter. We do a lot of work in the antitrust and IP area, and also litigation that I think we fall into those two areas, including trials and class action.
Hi, everybody can hear me? Microphone's working? Okay, great, thank you. My name is Michael Reese. I'm a class action attorney, primarily for plaintiffs. On the consumer side, I like to think do impact litigation, like was discussed at the lunch break. I'm the founder of Reese LLP, which was founded in 2008. We have offices in New York, Minnesota, and California. I've been appointed lead counsel in numerous consumer class actions, including MDLs, which Angelo will tell you a little bit about those type of cases during this presentation. Complete focus is on class actions. I also teach on class actions at Brooklyn Law School and lecture on them as well. And thank you again for inviting me to this session.
So we'll jump into the program. Just a high-level overview. We're going to start off with giving just some brief background on security incidents. We'll talk a little bit about Rule 23 issues that are arising in these data breach class action settlements. As Michael said, we'll touch a little bit on multi-district litigation, where a lot of these major data breach class actions are winding up. Touch on what the typical claims that are being asserted in these claims, these cases are. Tom will go over the defenses that are being asserted, and then we'll hop back to Michael to talk about the class relief being sought and the type of settlements we're seeing out there. And if we have enough time, we'll make some predictions for 2022 and beyond. So we'll talk about security incidents and what is giving rise to class actions. Pretty much any incident that involves unauthorized access to personal information, protected health information, can result in a class action. Class actions being filed within days of public announcement of data breach. And in these type of cases, the interesting thing is the company actually serves up an invitation for a class action with the notice that they provide, which is often Exhibit A of the complaints. What I've been seeing in my practice is that the class action can be filed regardless of the sensitivity of the information and the data involved. And a lot of the settlements I'm seeing are not driven by the sensitive nature of the data, just the unauthorized access and the number of individuals who are impacted. The primary security incidents giving rise to class actions. This is a chart that was created by the Identity Theft Resource Center. It publishes a report every year on major security incidents. This outlines the 1,613 publicly disclosed security incidents from last year, but primarily where we're seeing the most class actions filed are ransomware attacks, phishing attacks, the use of malware, which is a little similar to the ransomware attacks, and human error in terms of misconfiguration or publicly posted information on the public website. The good news for people who are practicing in this area is that class actions are on the rise. Security incidents are on the rise. Of the 1,600 publicly disclosed security incidents last year, there was a 41% increase in phishing attacks. For those who don't know what a phishing attack is, it's a scam where someone sends you an email that looks like it's from a legitimate source. You click on it. The threat actor then has access to your email account. They can compromise emails, intercept. Usually, generally what I see is intercept invoices, intercept wiring instructions, and they're typically used for financial gain. How it turns into a data breach class action is that while the threat actor has access to the email account, depending on how long they're in there, they have access to all the documents saved on there, to, from, deleted. And if those documents have sensitive information, personal identifying information, you maybe have an obligation to report a data breach, and if it results in class actions. I'm seeing a lot of phishing attack incidents involved in the healthcare space. Because some of the healthcare providers still don't use any type of multi-factor authentication, and B, because of the sensitive nature of the communications and protected health information that's being emailed back and forth. Ransomware attacks, although it's the second greatest number of incidents reported last year, next year, one of the predictions I will say is that it will be the first. It has gone up 103% since incidents in 2020. Traditionally, ransomware attacks were an encryption of your data. The threat actor would demand a ransom, you'd pay it, and they would unencrypt it. Over the last 3 to 4 years, ransomware attackers or threat actors caught on to backup tapes, the ability to back up the data. So now we're seeing a lot of what's called double dipping. At the same time that they're trying to lock down and encrypt your data, they're also exfiltrating information. So if the encryption doesn't work, they will demand a ransom for not publishing your information on the deep dark web. Last year alone, 84% of the ransomware attacks that were reported involved exfiltration of information and a demand for payment not to publish it. And with that all said, the number of class actions in major security incidents has risen, increased by over 44% from the amount in 2020. There were 27 major security incidents for public companies reported last year. All of them resulted in class actions. Year before, except there was 36. Year before it was 25, so there was a 44% increase. And it's going to continue to be on the rise as we continue to go forward, as technology continues to get more sophisticated, and as the threat actors become more successful in these types of security incidents. With that basic background in mind, I'm going to turn it over to Mike Reese to discuss Rule 23 implications of the class action itself. Let me just grab the
So I want to talk about the importance of class action, particularly with respect to data breach cases. And I think you need to understand the justifications of the class action device to understand why they're so important to data breach cases. One is that one of the justifications for the class action device, which is where I think we all know at this point in the conference today, are the claims of many people that could be resolved in one litigation. And I think it's probably the rare case that doesn't involve a very large number of people in a data breach case. We're usually talking about large corporations, corporations that have hundreds of thousands, if not millions, of affected people by a data breach. So it's not surprising, and we'll talk about some of these cases where the proposed class is 3, 4, 5 million people. So that's one of the justifications of class action devices, to resolve many claims in one action. So instead of having 5 million individual actions, which would overwhelm the court system, you have one case that could resolve all those claims. The second justification is that many of the damages that you see in these cases are relatively small. And as a result, without the class action device, the consumers, people that are affected by the data breach, wouldn't have necessarily the means or the incentive to bring the case. And this decision by the Seventh Circuit, Carnegie versus Household Intern, talks about these two very prongs and sums up this second point as only I think the Seventh Circuit can do, stating the realistic alternative to a class action is not 17 million individual suits, but 0 individual suits, as only a lunatic or a fanatic sues for $30. That's certainly true. And if you practice in litigation, if you have ever seen the invoice for the court filing, you know that it's I think $405 these days. So if your damages are $30, even though you hope to recover your costs at the end of the day, the filing fee alone is going to be much greater than the damages. So to quote Ben Franklin, and I think this is probably more plaintiff's perspective than defense perspective, we must all hang together, or surely we shall all hang separately. I think that really underscores why plaintiffs find class action so important, because without the class action device, you don't have really any cases going forward, unless you're that fanatic suing for $30. But I want to point out that the class action device is not one-sided. It's also a very valuable tool for the defense, because there's this idea that you can deal with all claims in one fell swoop. And we're going to go back to the Seventh Circuit, where they, in a very recent case from actually earlier this year in Simpson v. Dart, they talk about classes should be certified regardless of whether or not the plaintiffs are going to win or are going to lose. The rules are very straightforward, and if you meet those requirements, the class must be certified. It's not a merits examination. And why is this important? Well, think about it. If you have 5 million individual suits, and even though maybe you don't have 5 million suits that would be brought, but let's say you have 100,000 suits that would be brought, and you as a defendant, you don't want to have to defend against 100,000 suits, and you think you're pretty strong, you have a very strong case that you could win on summary judgment, you could win on trial, you think there's really no liability in this case, you could knock out all those cases in one fell swoop by winning at summary judgment or winning at trial. So it's not a one-sided device. And then you also have to think about it, and we'll talk about this towards the end of this presentation, is the importance of the settlement and the class action device with the settlement. So many cases, it's not a surprise after you go through rounds and rounds of discovery, if you survive a motion to dismiss, if you survive summary judgment, both sides know the weaknesses and strengths of their cases. So there's a very good chance the case will settle before you roll the dice with the trial, with the jury. And the class action device allows for you, the defendant, to sweep in all those claims through the class action device and settle those cases, settle all those claims. And the important thing is, under Rule 23, which is the federal rule that governs class actions, and that's where most class actions are, because in 2005, Congress passed the Class Action Fairness Act, which says if there's diversity between any of the parties in the class action, the proposed class action, and the defendant, and diversity means there's a difference between residents of the states, you end up in federal court. There's federal court jurisdiction, and that is almost always a situation, because in these data breach cases, it's very rare where it's only, the class is only members of one state. It's usually a nationwide class. So if you have a defendant that's based in New Jersey and a nationwide class is proposed, it doesn't even have to be a named plaintiff. If you have somebody from Kentucky, from California, you have diversity there, and it'll probably end up in federal court if not filed there originally. So let's talk about Rule 23. Since that's what governs almost, oh, bring the microphone, sure. Thank you. So Rule 23, it's in the Federal Rules of Civil Procedure, and it's fairly straightforward. To get a class certified, you have to satisfy all 4 prongs of Rule 23A, and then you have to satisfy one of the prongs of 23B, or if you're bringing an issues class, 23C4. The first prong is numerosity, and that, simply put, is the class is so numerous that joinder of all members is impractical. Now, you almost never see this actually as an issue, and many times the defendants in data breach cases may stipulate to this. There was at one point with some early cases where there's a challenge to numerosity over how interested the proposed class members were, how likely were they to make a claim. But after further thought, the courts backed off from that and said, that's not written in the rules. The rules are just, is it so numerous? And again, it's very rare when that's challenged because, as you can see from this case, the Brinker data incident case, which involved Brinker owns Chili's, which is a very popular restaurant. Probably millions of people go there. They had a data breach that involved potentially 4.5 million class members, and numerosity was not an issue here. When you read these orders, the numerosity section is usually a line or two, just citing the standard and then the facts of the case. The next prong of 23A is 23A2, which is there are questions of law or facts common to the class. Now, this usually is also not such much an issue. All that the plaintiffs need to show is that there's a question of law or fact common to the class. The claims of the class must depend upon common contentions that is capable of class-wide resolution. And why this is usually not an issue in these data breach cases, because you're not necessarily looking to how a consumer is interpreting a label or a contract. It usually is focused on the defendant and whether or not the defendant's conduct was negligent, whether or not the defendant had enough proper controls in place to prevent the data breach. So it's very rare to see commonality. It's often challenged, but it's very rare to see a court actually say you haven't shown commonality. So as this slide shows, you can have many different types of minions, but they're all minions, so the minion class is going to be certified. The next prong of 23A is 23A3, which is typicality, and this is the claims or defenses of the represented parties are typical of the claims or defenses of the class. This also very rarely trips up class certification. It's really to make sure that the interests of the class reps and other class members are the same. So really typicality comes down to, was this a person that could potentially have been affected by the data breach? So if you think about the Chili's situation, the 3 representatives in the Chili's case all had gone to Chili's, all had their data compromised. You can think of a scenario where who would not be a typical class member? Somebody who'd never gone to Chili's. Somebody who just was not a Chili's fan, and as a result, was not subject to this data breach. That would not be a typical. They may be typical for another case, because as Angela said, data breach cases are happening almost every other day, but not in this, the Brinker data breach case. So this is usually not an issue. Then you get to adequacy. And adequacy, again, is very rarely an issue. It's just making sure that the named plaintiffs, the proposed class representatives' interests line up with those of the class, that there are no conflicts of interest. The only time I've really seen this be an issue is perhaps the class representative is the brother of class counsel, or there's something else going on that seems really untoward, that the class representative somehow got a contract that would give the class rep more money by bringing this lawsuit, bringing that type of incentive. Courts frown on that. But typically, this is not an issue. It also looks at the adequacy of counsel. From what I've seen, is most of the practitioners in this space on the plaintiff side are well seasoned, if not specifically with respect to data breach, at least with respect to class actions. And you're usually pretty far along the litigation. The only time I've actually seen this trip up class actions is when, for some reason, the proposed class counsel have really irritated the judge by missing deadlines, by having discovery disputes where it seems like they're hiding something. But again, this is the rare situation. Most times, adequacy is never an issue.
And just to interject, if you're defense counsel, imagine how much fun it is for you to be making a motion saying, my adversary isn't good enough. I want somebody tougher and better.
And Tom, to go back to not necessarily my favorite court, but it is the Seventh Circuit talks about. I think there's a case from 1972 about when defense counsel makes that argument, they say it's a little bit like having the fox guard the hen house, right? They're not looking for better counsel, they're looking for no counsel. They're not looking for better class rep, it's no class rep. Because ultimately defense counsel's job is to not have the class certified. And not to dwell on this too much, but there have been instances, there are some judges in the Northern District of California where if they have an issue with the class counsel or class rep, they will put it out to bid. They say this class should be certified, you've met all the other prongs, I don't think class counsel is qualified, or they've irked me in some way. And so I want to find out who's interested in taking this over. And as we'll talk about in settlements, these cases are often viewed as being pretty valuable. And if you've already got a blueprint of a class certification, there's going to be a lot of hands that are going to go up and say, Judge, pick me. I won't make the same mistakes that those others did. So those are the prongs of 23A. Again, I think they very rarely trip up class certification. And when we're talking about class certification here, we're talking about in the form of a contested motion where plaintiff's counsel moving for class certification, defense counsel saying, you haven't met the prongs of Rule 23. They are the same prongs that are required to be examined by the courts in the settlement context, but usually, since it's not a contested motion, the parties are working together to get the settlement. It's very rare when it would trip up a settlement, though it does occasionally happen. And that's usually if an objector comes in, but we'll talk about that at the settlement stage of this conference. So 23B2 is interesting because 23B2 pertains to injunctive relief classes. And these are interesting because basically the plaintiffs are asking for the court to issue an injunction requiring the defendants to do certain things. And one case in particular is the Facebook case, Atkins v. Facebook from the Northern District of California. And in that case, the plaintiffs moved for both a 23B2 class, seeking the class to pursue injunctive relief, as well as a 23B3 class, seeking damages. I'll get to 23B3 in a moment, but to give you a little preview, the court there denied the 23B3 class, saying you haven't shown that there's, you can basically show damages. You haven't met the predominance requirement of 23B3, but you have met the requirement of 23B2 and certified an injunctive relief class. In that case, data was breached regarding Facebook. It was hacked. Approximately 29 million Facebook users worldwide, including 4 million in the United States, were potentially affected. And what the plaintiffs sought in that case, in addition to the damages, was a declaration that Facebook's existing security measures did not comply with its duties. Two, that Facebook would comply with its duties of care and would therefore have to implement and maintain reasonable security measures, including engaging third-party security auditors as well as testers. And ultimately, the case, as I said, motion for class certification was filed. It was opposed by Facebook and its counsel. Judge Alsop said, you haven't met the requirements of 23B3, you can't get a damages class, but I am granting 23B2. That case settled about a year ago, May 6th of 2021, received final approval from Judge Alsop. Many of the terms I just mentioned to you were part of the settlement, and the attorneys in that case received $6.5 million in a fee application. So even though injunctive relief may not seem to be as powerful a mechanism as the damages, it actually can be more powerful in some ways because you're actually requiring corporate change. So it's not just paying money, the money's gone, you don't have to look at that anymore, you can run your business the way you want to. You're actually having court order you how to run your business going forward. And sometimes the injunctions can be 5, 10 years, or really an unlimited period of time. So then the next prong, so you can either seek a 23B2 class or a 23B3 class. You can seek both, but you don't have to seek both. You could go purely injunctive relief, or you can seek a damages class without seeking injunctive relief. And that's actually an interesting issue because it brings up standing, whether or not once you've been damaged, do you still have standing to pursue injunctive relief? And Tom's going to tell you more about that. I know in the context of certain food labeling cases, the Second Circuit has said once you realize you've been deceived regarding perhaps the packaging, in fact that the Second Circuit leading case involves the amount of pasta in a box. And the court said once the named plaintiffs, Second Circuit said once the named plaintiffs realize that it's not filled to the top, they don't have standing to pursue injunctive relief anymore, and therefore can't pursue an injunctive relief settlement under 23b2. But Tom will explain more about that. So damages class is usually, that's where the real battlefield is. There's two prongs to Rule 23b3. And I'm not going to read these slides because I think you all have access to them. If you don't, I will certainly make sure you have them if you want them. But predominance is really the big issue. And that's, can you prove damages on a class-wide basis? And the courts are split on this. It's very difficult because going back to the Brinker data breach case, you had the 4.5 million potential class members, but not every class member was impacted in the same way. In fact, many class members may not have even known that their data was breached. So how do you measure those type of damages? I think if there's anything that can be drawn from this, if you're comparing the Hannaford case with the Brinker case, is you need a very good expert. So in Hannaford, they try to do this without an expert. And the court said, met 23A, one, numerosity, you got commonality, you got typicality, you're adequate, but you didn't get an expert. You haven't told me how you can show damages on a class-wide basis. You haven't brought forth an expert, at least to give me a model to consider, and denied class certification in that case. And ultimately, that case was dismissed. In comparison, the Brinker plaintiffs, maybe realizing from the Hannaford decision that they needed an expert, came forward with an expert. And the expert really used more like statistical analysis and try to average what the damages would be. And the Supreme Court has allowed that in certain type of cases and said this is what the damages could be expected. What's also interesting is some of these statutes have statutory damages, which makes it easier, at least as far as damages. Now you still have to show injury, which is a standing issue, which Tom's going to talk about. But I think when you boil it down is if you're going to get a class certified for 23b3, you need an expert that can show class-wide damages on some type of class-wide model. Courts usually don't require you to actually do the calculation, but some do.
Just let me jump in. One of the defenses that I was asserted at that stage is lack of traceability. Go back to the slide of all the security incidents. If you have an expert on the defense side that can go in and look at how many times a named plaintiff has been subject to a data breach and how many times the same information that they claim is exposed in your case has been exposed in prior cases, it's a very good defense to a post-class certification. There are experts that can do deep dark web search or just look at public records to demonstrate that the named plaintiff may have had 26 prior data breaches for the same information. They're going to have a tough time establishing traceability.
Yeah, and it's an interesting point, Angela, because as you point out, you're getting more and more data breaches, which is you're getting more and more sophisticated cyber criminals, and so that might become even a more tenable defense because everybody's data is going to be compromised several times over by the time you may figure out that you've been involved in one particular case or not. And it'll be interesting to see how the courts deal with that too, because there's a practical aspect of it that seems, I'm sure the courts must struggle. Well, even though your data may be compromised in another case, is it really fair that you can't now pursue a class action because of that? And then finally, let me just get back up to where we were. The last prong is superiority, which is almost never an issue. And that boils down to really two things. Is there some type of other litigation going on that might be a superior mechanism? And the times you see that are maybe there's a government effort, but oftentimes there's if not cooperation, at least distant mutual respect between the government regulators and the attorneys pursuing the class action through the private litigation. But I think courts really say, would I rather have 1,000 cases to try or one? Which one is superior? I'm going to go with one. So superiority, again, it's very rarely where you see these cases tripped up. I think it comes down, for the most part, to predominance. That's really the real battlefield it is, and it's tricky. It almost always requires experts. I think if you're going into seeking a 23b3 class certification and you don't have an expert as a plaintiff, you need to really reconsider working in this space. I think with that, I hand it back to you, Angelo.
I'm gonna go quick and touch on multi-district litigation so that we have time for the headliner, Tom, to speak about the defenses in class actions. But if you're practicing in this space, one of the procedures that you should be aware of, and where a lot of the major data breach class actions are going, is multi-district litigation. They're being consolidated and coordinated for the purpose of pretrial proceedings. They're technically still independent individual cases, but they're all venued in a same court where they were be administered by a single judge. And what they look for are there common questions of fact to be addressed. They want to have that done at the same time in one district court in order to help promote efficiencies. If you're looking for the purposes of it and you're bringing an application to the judicial panel on multi-district litigation, you want to be able to essentially outline 3 elements and advance the purpose of it. One is do the civil actions that you seek to have consolidated, coordinated, have common questions of fact. One of the things that you have to weigh that against when you are a defense counsel is, all right, I'm going to bring an application to the judicial panel. I have to show common questions of fact. Is that going to come back and backfire on opposition to class certification? 2, will the transfer be convenient for the parties and the witnesses? And then 3, will the transfer promote efficiency, cost savings, and fairness? And generally speaking, courts on the larger type of class actions and data breaches tend to create an MDL. And they do so because they want to eliminate duplication and discovery. They want to avoid conflicting rulings, enhance scheduling so I don't have to produce, if I'm a defendant, the same 30B6 witness 27 or 28 different times. They hope to reduce litigation costs and save time and effort for the parties, the attorneys and the witnesses. Some of the advantages of multi-district litigation, and I'll say this with a disclaimer that advantages on this side are being presented by defense counsel, and Mike may say, we're going to take this slide and turn it into disadvantages of an MDL, but I'll just lay them out. One is you avoid conflicting rulings. You reduce the burden on pretrial motion practice. You usually have one judge issuing pretrial rulings on motions to dismiss, some unique discovery issues, some expert issues, conclusion issues in one ruling. You have the ability to coordinate your discovery and lessen the burden or drain on a company that has hundreds of these class actions. You also have the ability to use bellwether trials or bellwether complaints. These are essentially test cases. They're used to try to predict the outcome. In some instances, they're really good to help foster settlement. It's not always an advantage for either side, and you have to weigh whether or not a true bellwether will work. Where I have run into issues with it is that the plaintiffs will want the best case, the best claims, and the defendants will want the worst case and the worst claims, and you have to try to negotiate and then deal with the judge on ruling of, is a bellwether trial the best way. The other alternative is doing sequencing, where you just sequence on certain issues, get those resolved, and hopefully those rulings will help guide you toward a settlement. And the best advantage of an MDL, I think, is that it fosters global settlement discussions, and you have a court that is motivated in assisting and managing that process to get to settlement. Some of the disadvantages, primarily one is the fate of your case is going to be in a single judge. And while you can make an application and you can ask for a judge, you can even agree with the judge with your adversaries, If you get on the wrong side of the judge, or you get the wrong judge, that judge has great authority, and you're riding that train throughout all pretrial proceedings. Second, when an MDL is created, the volume of cases, in my experience, tends to increase because of the publicity. So now you're having more filings. Third, it allows plaintiffs to avoid the cost of funding class action. Back to my original disclaimer, that's probably a benefit for plaintiffs. With defendants, you want the economics of the litigation to try to work its way through. I have seen MDLs have a much slower pace, given the high volume of cases, the number of issues, the type of briefing involved. Stronger parties will tend to lead the case and help weaker parties develop a case. So there'll be steering committees, defense counsel, plaintiffs counsel, and they will run the cases through the pretrial coordinated proceedings. And then you're in an MDL and you seem to have that balance of, am I giving up arguments on commonality and typicality to get into this MDL? So you have to balance all of those. But regardless of the advantages and disadvantages, these cases, the larger ones, are all going to MDLs. Here's a list of all the recent large data breach class actions. There have been applications filed to the joint panel on multi-district litigation, and by and large, they're being sent over to the MDL for the efficiencies and the ability to try to achieve a global settlement. With that, I'm going to turn it over to Tom, and Tom will be talking to you a little bit about the claims asserted and the defenses.
Thank you. Let me see if I can operate this technical. Okay, we are. The first subject I want to talk about is Article 3 standing. So if we're in federal court with a class action, the data breach cases particularly bring this Article 3 issue to the fore because by their nature, you have consumers who say, my data has been accessed. And to have Article 3 standing, to have the federal court have jurisdiction, it can only have jurisdiction over cases or controversies. And a case or controversy has to have three elements: an injury in fact, causation, what caused the injury, and redressability. The decision of this court is going to solve the problem. And Spokio, I put this down in case Spokio against Robbins. That was the case in 2016 that was supposed to come forward and clarify this, what had been a split in a lot of courts in the country, in circuit splits. In that regard, we've listed a few of them. Krotner versus Starbucks Corporation. Starbucks had a company laptop that was left and it was stolen. And so someone could access people's data, the employees' data. So the employees brought a class action saying, hey, my data is there. Anybody could be getting this. And out in the Ninth Circuit, they looked at this and said, yeah, that really does sound like an injury. In fact, it's terrible. You're going to be up all night worrying about what's happening to your data. You have that injury in fact. In contrast, a lot of courts, Riley against Ceridian is a nice example. The Third Circuit took a very different view. And the Third Circuit was saying, okay, so you're worried about your data being accessed. How have you been harmed? Has something happened to you? Now, in contrast to the Krotner case against Starbucks, where you just had a plain old theft. Somebody stole a laptop and they were worried about their data being accessed. In Ceridian, this again was a payroll company. And the employees said, the company has been hacked. People have gotten into our company's system and gotten all this information, including direct deposit information. That sounded a lot more serious, at least to me, than the laptop issue in Starbucks. But the court of the Third Circuit said, no, just because some hacker has gotten in there, that doesn't necessarily mean that they're going to use the data, that you're going to be harmed by the data. Now, other courts look at that and say, you got to be kidding. Why do we have these people going in and getting the data, if not to harm somebody, to use it, to make a buck out of it? But that's where the split was. A case came along, Clapper, against Amnesty International, the Supreme Court. That's James Clapper, the former CIA director. And there you had people in Amnesty International saying, the government has set up these Foreign Intelligence Service Act courts to determine whether the government can go in and surveil target foreign entities. And they could be talking to me or to somebody else in this class in terms of eavesdropping on us. And the Supreme Court looked at this and said, no, this is not direct, concrete harm. You don't know if they're actually surveilling you. By law, they're surveilling foreign entities, not US citizens. Number two, they've got to go to a foreign surveillance court to get authorization to do that. Number three, we don't know what they're going to find. If you're going to be talking to this foreign entity, it's all speculative. So you don't have that standing. Clapper was decided not picking up that central question of, are you harmed when your data is accessed before you know it's been used to harm you? Clapper really was decided on those unique facts and didn't do anything to clarify it. So what you have is, after Clapper, the split continues. Did I miss something there? Let me fast forward through that, because I want to get to this. So then comes Spokio. Spokio was a case before the Supreme Court where this guy, Thomas Spokio, sued under the Fair Credit Reporting Act. Apparently, they got the information wrong. They had him with a resume that looked better than he actually has. They had him married with children, having an advanced degree, actually being employed now. He was looking for a job, and his complaint was, I've been injured under the Fair Credit Reporting Act because this makes me look like I'm better. So I'm not going to get job offers from a lot of the companies that might otherwise hire me. So the Supreme Court gets this case and said, well, you do have a right under the Fair Credit Reporting Act. It has to be accurate information. It does give you a right to go forward with a claim, but were you harmed by this information? And Justice Alito, who also was the author of the Clapper case, he comes in and he said, let's look at the type of information. Suppose it was a zip code that was inaccurately stated. Would that give you harm? Yeah, it's a violation of the Fair Credit Reporting Act. It's inaccurate information. But are you harmed by that? And are you harmed? Is that concrete harm that lets you stand in federal court? And with this, the court said then, we're going to send it back to the Ninth Circuit to determine whether this was the type of harm that the statute was meant to redress. And Justice Ginsburg, I should say my civil procedure professor, Justice Ginsburg, she wrote a very nice concurring opinion saying, look, this is someone who's been harmed. It's this person's prospects that have been harmed. So she takes a future look. Haven't been harmed yet, but your prospects now have been harmed. And the Ninth Circuit, quite predictably, because if you remember the circuit split, the Ninth Circuit, they haven't seen a class that doesn't have standing. Maybe that's a little bit too much, but they're certainly, the Ninth Circuit, the Seventh Circuit, they've been much friendlier toward finding class certification and standing than the Third Circuit and some of the other circuits. two of the cases that are on this list, one of them is Thomas against FTSA USA. And that one actually, it's a failure to notify, the Fair Credit Reporting Act, failure to notify in advance of sharing credit reports. And you look at that again, okay, you didn't let him know in advance that you were going to share the credit report with someone, an employer, prospective employer, and they said, that's harm, you have standing, go forward. There are other cases, though, where Hancock against Urban Outfitters, this was a DC statute under the DC Consumer Protection Procedure Act, where they said, you don't really, they provided your zip code. Again, the zip code, the same thing Justice Alito was talking about, the zip code when you went to make a charge transaction, a Visa or MasterCard. And this DC statute prohibited that. But the court there said, yeah, well, it's prohibited, but you weren't harmed by that, and you really don't come under this, so you're out of court. The other thing to think about, too, is what is the harm that people are suing for? So in some of these cases, even after they establish standing, they then have to prove actual damages. Now, if it's a statutory cause of action, sometimes they will have, the statute will provide, here are the damages that you are going to get by statute for this incident or for these incidents. But if you have to prove that you actually have suffered damages, a lot of what you see are people going in and saying, well, I had to hire someone to monitor my credit report. I've had to call the credit card company and have them cancel cards and issue new ones. That's time and effort on my part. For some courts, they'll say, yes, that's injury, you've been injured in fact. Other courts look at those same facts and say, you're just protecting yourself. You haven't been injured by them. How do we know that you've been injured by any of these people and it's going to happen? So that really still goes on today. It hasn't been resolved by Clapper, it hasn't been resolved by Spokio. But I think that you find, in my view, clever plaintiffs lawyers who can find a way to say, yeah, there's injury here and we're entitled to be in federal court. One of the things I did want to point out is this idea in federal court. I might have copies of the mic on it here. As a defense lawyer, if you're representing a company that's been sued by a consumer class action, typically what you do is you remove it to federal court. And as Michael was just alluding to, CAFA, the Class Action Fairness Act, allows almost all class actions now can get removed to federal court because you have minimal diversity, not complete diversity, so it's much easier to get into federal court. And one case that I found particularly interesting, because I did this once, I removed to federal court, and then when I got to federal court, I told the judge, we have a standing problem here because no one's actually been injured. This case isn't right. And the judge, after beating me up for an hour or two in court, said, yeah, here's a 98-page decision. Yes, you're right. But there's a case that shocked me, because it's this one on removal, Mosick versus All Saints. And the court there, what the defendant did was to remove it to federal court and then argue that the court lacks jurisdiction. And the judge said, if you had, what you're saying now is that you remove the case here and you say, I don't have jurisdiction, I'm going to sanction you. I want to get that language. It's a little surprising, at least to me it was. But it said, to be clear, there's no question that if defendant wished to litigate the merits of plaintiff's federal claim in a federal forum, it was free to remove the case and seek to establish federal jurisdiction, regardless of whether it may ultimately have concluded that plaintiff lacked standing. But defendant did not pursue that avenue. Instead, defendant tried to have it both ways by asserting, then immediately disavowing federal jurisdiction. And that sort of, the judge perceived that as gamesmanship and said, you're going to be sanctioned for that. I'm going to remand this to state court. So that's another one. I guess I'm trying to just buzz through this thing. Last thing I'll talk about is the safe harbor laws. A number of states, increasing number of states and federal agencies have enacted legislation or have enacted some type of regulation. HIPAA has a safe harbor provision. HIPAA, again, that doesn't provide for a private cause of action, but for a violation of HIPAA regulation, but it has certainly fines are going to be levied. Ohio has come out with the Data Protection Act, which provides an affirmative defense. And it said, if you do all these things, if you establish a data security system of cybersecurity safety precautions that's recognized by one of a variety of bodies, then you will have a defense that you can assert if you're sued for a data breach of your system. Utah has just very recently enacted the same type of situation. Connecticut doesn't give you a complete affirmative defense, but it enacted one that eliminates punitive damages. Can't get punitive damages if you comply with these precautions. So there are some safe harbors, but the data breach cases for companies, a lot of the class actions you see, antitrust cases, things like that, it's one big company a lot of times against another big company, or sometimes it's a lot of consumers who have paid big bucks, or maybe little bucks, like a can of tuna, very recently in the Ninth Circuit. They were looking for class certification, but the data breach cases, it's harder to see the damage. And as some courts say, what does the person have to do? Wait until their data is accessed and they're damaged before they can sue? Why are these hackers going in there and getting it? It can't be good. So there's been that back and forth, and that's where the arguments are.
Right, just to jump in real quick. One of the things that we should be aware of is a standing issue at the settlement approval stage. There's a case, Ramirez versus TransUnion. There are at least 3 decisions that came out last year where a court said, I don't have standing to approve this settlement. One is in the Middle District of Florida. It is the Hines case. Second one is the Eastern District of Pennsylvania, the Clemens case. And the third one is from the Western District of New York, the Scharfman case. So just be aware of standing. And then the other standing decision that I would direct you to is the Second Circuit's decision in Morris, where they did a evaluation of all the different circuits and came up with a 3-part test for standing. Because it was in 2001, the only courts that had followed it have been district courts in New York, but I do think that that is going to be where these standing decisions go, that 3-part analysis that looks at fact-specific factors. Go ahead.
If I could, Tom, I just wanted to follow up on that because it's a very interesting point that you make about standing, and I think it's particularly interesting because I've had cases where we filed in the state court in California. They've then been. Oh, I'm sorry. I'll start with Tom. That was a very interesting point that you made.
Say it again louder.
Well, my next slide is. But it's interesting for a couple of reasons. One is I've had cases we filed in the state court in California which does not have an Article 3 standing requirement. If you violate the statute, you have a right to pursue the remedies. And many of these statutes provide for statutory remedies. You don't have to show injury in fact like you do if you're in federal court. And why it's so interesting is those cases were removed. They made an Article 3 standing motion. We didn't move for sanctions. That's not the way we practice. Though, as we know, courts can do that sua sponte if they want. The cases were remanded where they're being litigated. And why it's particularly interesting I think from both the plaintiff side and the defense side is, one, if you're in state court, it could be a very different type of class, right? The look of it. If you think about it, many of these cases that are in federal court, like the Brinker case, the court actually changed the class definition to basically say people who have been damaged out of pocket expenses or other really kind of concrete damages, and not just my data has been exposed. But you don't have those same limitations necessarily in a state court. And so if your data was hacked, even though you may not have any expenses, even though most of the class members may not know that they were hacked, that may be much broader. So I think from the plaintiff side, if you can stay in state court, all the better. They may welcome an Article 3 argument in federal court because they send us back to that broader package. And on the same point, if you're a defense counsel and you want to settle the case, you may want to do it in state court because you don't have that same standing issue, depending on the state. Because of course, when you settle a case, you want as broad a settlement as possible, and you don't want these standing issues to get in the way. And as I mentioned before, the Second Circuit recently rejected it, back in 2021, rejected a 23B2 settlement saying, once you found out about that's a consumer protection case, but once you found out about it, you don't have standing anymore to pursue these injunctive claims.
And not all states have that lack of case or controversy requirement. I think California, Massachusetts, and New Jersey. I don't know if there are others, and don't rely on me if Massachusetts or New Jersey or California have changed their laws. But check it out before you rely on that strategy, because the states are very limited who don't have that requirement.
You have a question?
How effective are defenses where, for example, a private asset manager has their client and they sign on, essentially assume the risk of data breach, theft, out of, these firms try to have cybersecurity, but it only goes so far, and if everything's so up in the air the way you're describing it, if you really don't have cyber warfare with Google, for example, a very real place would be in tackling financial institutions.
These two scholars are going to talk about predictions for the future. I'm going to blurt out mine. I'm seeing Armageddon.
Yes.
What can happen in a cyber breach? It's like the spy versus spy. You try to build up your defenses and they try to figure out a new way to penetrate it, and you go back and forth. And sooner or later, one of the shots is going to hit the mark and get this information. And when that happens, it can be catastrophic. At one time, cybersecurity insurance, that's one thing to look at. But if you look at your policies and what's going on, you're going to have sublimits. You're going to have it's going to be limited. It's going to be limited. So you'll be paying the premiums, but be careful of how much you can rely on it. And if you realize that some of these things, if you're a big investment bank, if you're a law firm and you're dealing with billion-dollar transactions and secrecy is important, and someone decides to publish that, forget about the consumers. Worry about what's going to happen to your company.
On your question though, I don't think you could have a disclaimer that says I'm not responsible for anything, but what I'm seeing is when I'm collecting your data, there'll be a class action or a arbitration provision, a class action waiver in there that you're providing me your data for this benefit. If there's any issue with respect to my treatment of it, it'll be resolved in arbitration and there'll be a class action waiver. I think that has a much greater chance of success of being enforced as opposed to, we'll do our best, but we're not responsible for anything. You're not going to leave them with any type of remedy at all.
And arbitration is a very interesting topic because I think it's hotly contested both in the courts and in Congress. There's been talk, but I think it's been talk since Concepcion was ruled on by the Supreme Court over a decade ago that the Democratic Congress is going to change it. There have been nibbles at getting rid of arbitration, at least in the class action context. But I think the point is well taken is that if you get a class action waiver, particularly I think with an arbitration, because I think courts don't like lawyers telling them how to run their courts, and if they think there should be a class action, that's the best way for the case to proceed. That class action waiver is not going to have as much important with them, but you always see them tethered with arbitration provision. And I think what's interesting is, in the context of injunctive relief, if you have a class action waiver, you're not going to get these mega settlements of $380 million like the Equifax settlement, but you still can get meaningful injunctive relief. And you see this being really litigated in courts in California because there's a special provision of California Civil Code that prohibits waiving public injunctive relief claims. And that's the McGill decision, which came down, I think, about 5 or 6 years ago and has been adopted by the Ninth Circuit, which is important because most of these cases aren't in federal court.
You want to just hit real quick on class relief?
Sure.
For 2 seconds?
Sure. So I'm not Kevin. Kevin was unfortunately not, Al-Qaeda's not be able with us today. He's sick, but he put together these slides. I'm sure if anybody has questions, he'd be happy to answer them if you want to send him an email. Probably, highlight is a common fund or a claims made fund. And the big difference there is common fund is you set aside a pot of money, let's say go to crypto, 100 Bitcoin, which might be worth $1 billion on the market tomorrow. And none of that money goes back to the defendant. So hopefully all of it will get paid out to class members after you have cost of notice, administration, attorney's fees. But if not, there's often a side prey recipient versus claims made, which is there's no pot of money, and the claimant has to make a claim to get the claim, which is usually the case with a common fund. There are rare situations where money can just be funded back if it's involving banking, but most class actions, even if it's a common fund, involve a claims process. There are advantages and disadvantages to them. Claims made is often you see that with smaller settlements, and there's often an ability to pay, but sometimes it can result in class members getting a bigger payment because it's not focused on a pro rata decrease or increase of a fund. You're going to get a concrete amount of money.
Yeah, and really sorry, that claims made, what you're seeing are compensation for lost time, and it's anywhere from $15 to $20 per hour with a cap of 3 to 4 hours that plaintiffs class members can file an affidavit to say, I spent this amount of time trying to correct my credit and my identity. 2, you're seeing compensation for ordinary expenses, which would be, I had to fill up my gas tank to go to the bank, so I'm entitled to that, postage, FedEx. 3, there's a component for claims made for extraordinary expenses where there actually is identity theft and it's not covered by a credit card company or someone else, but they have extraordinary expenses that are defined in the agreement. And then there's generally also a non-monetary component to the settlement, which are what are the improvements that the company or defendant's going to make in order to be able to prevent or reduce the risk that's occurring again.
Maybe this is a good segue to the prediction, especially since I think we're over our allotted time, and that's the Yahoo data breach. I understand that's there's a settlement there, a large settlement in front of Judge Koh, who is I think now in the Ninth Circuit. That there was objectors to that case. Argument was held before the Ninth Circuit in February of 2022. And there are very few of these cases that have made it to the appellate level. The Equifax did make it to the appellate level. The appellate court, the 11th Circuit, affirmed the order granting final approval, but this is certainly one to watch.
But my prediction is that there'll be a lot more data breaches. There'll be a lot more class actions filed, and standing will go back to the Supreme Court. The Supreme Court is going to expand Ramirez and make sure that there is an imminent threat of harm for a class to be certified. And I do think that these cases after a Supreme Court ruling are going to shrink with the standing rule.
And thank you very much.